Good afternoon, and thank you for joining our firm webinar, OSHA COVID-19 Vaccination and Testing Emergency Temporary Standard, What Employers Need to Know. I am Gail Holtzman, a member of our Labor and Employment Law Practice Group, and I am pleased to be able to help guide you through this new rule. Just going to, okay. Karen, can you go to the next slide?
Gail, I'm trying to, hang on.
So during this next hour, I'm going to be providing you with an overview of what steps you need to take and the timeline for these actions. For those of you who sent in questions, we appreciate those, and I've tried to incorporate responses to those questions into the presentation. So first, what is required of you under this new OSHA, sometimes I'll call it an emergency temporary standard or rule? So covered employers first must establish, implement, and enforce a mandatory vaccination or testing and face covering policy, provide paid time off for employees to get the vaccine and recover from side effects, maintain records and preserve proof of employees' vaccination status, and remove from the workplace employees who test positive for COVID-19 or who receive a COVID-19 diagnosis. So next slide. I'm going to try to turn off this noise. Okay. So stay tuned, because as Karen indicated, we're not quite sure what's going to happen with this rule. Prior to joining this webinar today, I was listening to the Supreme Court oral argument on this very ETS. The Supreme Court is hearing as we speak whether or not to lift the stay that prevented enforcement of the OSHA rule. So there had been a prior decision by the Sixth Circuit to enforce and lift the stay, and the court is considering what to do with this. And I can share with you from the oral argument and the questions that were asked by the justices the concerns raised on each side. So those seeking to stay enforcement, including state governments and trade associations and others, argued that OSHA does not have authority to require all of this in the workplace, that the rule is not sufficiently narrowly tailored, that that employers will lose employees if because of this vaccine requirement, along with the alternative testing and face covering policy. On the other side, the government argued that this is exactly what OSHA is here to do, that OSHA is here to protect the health and safety of workers, and that Congress granted that authority to OSHA, that if this rule is not enforced, that employers will lose employees to COVID, and that it presents grave danger to employees, that they could be exposed within 15 minutes of working closely with each other, and so that this rule should be enforced. So we should have a ruling possibly within the next few weeks, and of course we'll continue to keep you apprised. Next slide. So who are covered employers under this rule? Does this apply to you? And the rule covers private employers with 100 or more employees, and including part-time and temporary employees, of course, not independent contractors, and not employers subject to the Safer Federal Workforce Task Force COVID-19 safety guidance for federal contractors and subcontractors. That's the executive order in the construction industry, and it does not apply to settings for healthcare workers who are subject to Medicare and Medicaid. And an added point, the Supreme Court today will be hearing oral argument about the vaccine mandate for healthcare workers, the second bullet point there. Next slide. Leased employees. I know there have been a lot of questions about leased employees and what do you do if your company has leased employees? Well, if so, they are counted by the staffing agency for purposes of that 100 employee threshold for coverage. But for purposes of the policy requirements, employers are subject to the Department of Labor guidance for joint employers, where they share responsibility for ensuring worker safety and health. So if you have questions about that and you have leased employees, it's important to understand your shared and joint obligations, make sure there's good communication with the staffing agency. Next slide. The rule also addresses situations where there are multi-employer work sites. So, for example, on a typical multi-employer work site, such as a construction site, each company represented, that is the host employer, the general contractor, and each subcontractor would only need to count its own employees. And that said, each employer must count the total number of workers it employs, regardless of where they're reporting to work on a particular day. It is not site specific. So for example, if a general contractor has more than 100 employees spread out over multiple construction sites, that employer is covered under this rule, even if it does not have 100 or more employees present at any one work site. Next slide. So even if an employer is covered because they're a private employer and they employ 100 or more employees, they may not need to apply the policy and the requirements to certain employees. And so what employees are exempt? Well, covered employers do not need to apply the standard to employees who do not report to a workplace where there are other individuals, such as coworkers or customers that are present. And employees don't need to be subject to these requirements while they're working from home or they're working exclusively outdoors. And with regard to the requirement about working exclusively outdoors, the typical example that's been given is landscapers, that maybe there's a de minimis amount of time that they're indoors for a bathroom break or lunch, but they're working exclusively outdoors for all intents and purposes. Next slide. So effective date and compliance dates, of course, this is all subject to what the Supreme Court decides to do. And in fact, one of the questions that was asked today was about, during the oral argument, was about whether or not there might be an administrative stay. So we're not quite sure exactly what whether this will be delayed, but right now the requirements for January 10th, which is Monday, include everything but testing. So that means employers need to establish a policy on vaccination, determine the vaccination status of each employee, start obtaining proof of vaccination, maintaining records and a roster of vaccination status, providing support for employee vaccinations, requiring employees to promptly provide notice of positive COVID tests or diagnosis, remove employees from the workplace if they test positive, and ensure that employees who are not fully vaccinated wear face coverings when they're indoors or when occupying a vehicle with another person for work purposes. Also, they must provide each employee information about the rule, about the policies, procedures, even vaccination efficacy, safety and benefits of vaccination, protections under this rule against retaliation and discrimination, information about penalties, including criminal penalties for employees supplying false documentation. They must report work-related COVID-19 fatalities to OSHA within 8 hours, and work-related COVID-19 inpatient hospitalizations within 24 hours, and make sure that they have records available to provide upon request. And I'll talk a little bit more about that. So February 10th is the requirement that the date where employers must ensure that employees who are not fully vaccinated are tested for COVID at least weekly, if in the workplace at least once a week, or within 7 days before returning to work, if they're away from the workplace for a week or longer and require face coverings. So here are some dates for completion of a vaccination series by February 9th, so you know who would be required to be tested. So for the J&J vaccine, the primary vaccination series takes 1 day to complete. So the dose, employees must get this dose on or before February 9th to be exempt from the testing requirements. For Pfizer, it's a 2-dose series, and they must get their first dose on or before January 19th, and then their second dose 21 days later. Moderna is a 2-dose series as well. There's a 28-day span between the 2 doses, and the first dose must be given on or before January 12th. So first we'll talk about the mandatory vaccination policy. Of course, this rule provides for alternatives, and it was argued before the court today, well, this isn't a mandatory vaccination rule because there is an alternative for testing and face coverings, but the rule strongly encourages employers to implement a mandatory vaccination policy. And so first we'll talk about that policy if you so choose to require that for your workforce. So this policy requires that if it's adopted, that every employee is to be vaccinated, and the policy requires vaccination of all employees, including vaccination of all new employees as soon as practicable, other than excluded employees. And we'll talk about who is excluded under the mandatory vaccination policy. So excluded employees are employees who don't have contact with others. I had referenced that earlier, that the rule would not apply to those individuals. It also would apply to employees for whom a vaccine is not medically recommended, or a vaccine must be delayed for medical reasons, or employees who are legally entitled to a reasonable accommodation under Title VII of the Civil Rights Act, or the Americans with Disabilities Act, because they have a disability under the ADA or under Title VII, have sincerely held religious beliefs, practices, or observances that conflict with the vaccination requirement. So under this process, there's to be an interactive process between the employer and the employees who request an exemption to determine to address the request for the accommodation, and then what accommodations may be made. So important to understand the federal rights that are at play there. So paid leave for vaccination. Employers under the rule are required to support the vaccination for each employee by providing reasonable time to each employee during work hours for each of their primary vaccination dose or doses, including up to 4 hours of paid time that cannot be offset by other leave at the employee's regular rate of pay. So employers are not obligated, however, which is good news for employers, to reimburse employees for transportation costs incurred to receive the vaccination, but they do need to provide the paid leave for the vaccination doses. So what happens if the employees are vaccinated outside of work hours? The rule provides that if an employee chooses to receive a primary vaccination dose outside of working hours, employers are not required to grant paid time to the employee for the time spent receiving the vaccine during those non-working hours. But employees under the rule are required to receive some time to recover from the vaccine if they have side effects, so that employers do need to provide leave for that. And we'll talk a little bit more about that. So if an employee already has accrued paid sick leave, an employer may require the employee to use that paid sick leave when recovering from the side effects after the primary vaccination dose or doses. So they can't use the accrued leave to go get the vaccine during working hours. That has to be paid, but they can use the accrued paid sick leave for recovery from side effects if they're not feeling well. Additionally, if an employer does not specify between different types of leave, like they just have a PTO, paid time off policy, the employer may require employees to use that leave when recovering from the vaccination side effects. And if you provide employees with multiple types of leave, such as sick leave and vacation leave, you can require employees to use the sick leave only when recovering from the vaccination side effects. So what is a reasonable time to recover from a vaccination? The standard doesn't specify the amount of paid sick leave that the employer is required to provide for that purpose, but employers are entitled to set a cap on the amount of paid sick leave available to employees to recover from side effects. But of course, the cap must be reasonable. So generally, OSHA presumes that if an employer makes available up to 2 days of paid sick leave per vaccination dose for side effects, that would be in compliance with this requirement. So it may be a case-by-case situation, but that's a general guideline. So if there are questions about that, you always want to consult and make sure you're in compliance. So let's talk for a minute about the alternative COVID testing and face covering policy if you decide you don't want to have a mandatory vaccination policy. So for each employee who is not fully vaccinated, you must test employees and require face coverings. And you must test an employee, as I mentioned earlier, who reports at least once every 7 days to a workplace where others, such as coworkers or customers, are present. It's a weekly, every 7 days, and there must be documentation of the most recent test result to the employer no later than the 7th day following the date on which the employee last provided a test result. So when they report to work the following Monday, they need to present the positive results of the test in order to return to work. So the employee needs to get that done in time to provide the test result upon return. So typically, an employer may have in its workforce unvaccinated and vaccinated employees. Even if you adopted a mandatory vaccination policy, there may be employees who are exempt because they have a disability or hold sincerely held religious beliefs. So in that case, you're going to have a workforce that has both vaccinated and unvaccinated employees, and you need to cover that in your policies. So even though you address the issues regarding vaccination, you would also include the policy and procedures as to those employees who are subject to the testing and face covering policy. So weekly testing, let's just go back to that by way of an example. If an unvaccinated office employee has been teleworking for 2 weeks, but must report to the office where other employees will be present on a specific Monday, that employee must receive a COVID 19 tests within the 7 days prior to that Monday and provide documentation of that test result to the employer upon return to the workplace. And as I indicated earlier, the test must occur within the 7 days before that Monday because the employee must allow time for the results to be received and provided to the employer. So what is a COVID-19 test? This was one of the questions that I've recently received. A COVID-19 test is a test that's cleared, approved, or authorized, including emergency use authorization by the Food and Drug Administration, and that is administered in accordance with the authorized instructions and is not both self-administered and self-read unless observed by the employer or an authorized telehealth product. So this second bullet point is the one we're getting a lot of questions about. How does the employer maneuver through this to observe? And depending upon your workforce, you may choose different options. There are companies that are providing these services. There are ways to do it electronically. So there's some practicalities here, and you really need to think through how you are going to accomplish this and what's best for your workforce. Face covering requirements. So we'll talk a little bit about what's required there. So employers must ensure that each employee who's not fully vaccinated wears a face covering when indoors and when occupying a vehicle with another person for work purposes. And there are very limited exceptions, such as when an employee is alone in a room with floor-to-ceiling walls and a closed door. Also for a limited time while the employee is eating or drinking at the workplace, or for identification purposes in compliance with safety security requirements. I know that when you're traveling and you go through TSA, for example, they'll ask you to pull down your face mask so they can make sure that what they see, it correlates with the documentation you're providing to them. And also a face covering is not required when an employee is wearing a respirator or face mask under OSHA. So there are very specific guidelines about face coverings and how they need to be worn. And if you've been on an airplane traveling during this period, you'll hear flight attendants making announcements about how passengers should be wearing their face covering. It can't be under their nose. Certain requirements to make sure the protections are in place. So under this rule, the face covering must completely cover the nose and mouth. It must be made with 2 or more layers of a breathable fabric that's tightly woven, and the test is whether light can pass through. It must be secured to the head with ties, ear loops, or elastic bands that go behind the head and fit snugly over the nose, mouth, and chin with no large gaps, no holes, and no opened valves as are found on certain masks. So what about paying for testing? We've covered the fact that employers must pay for employees to be vaccinated during working hours and can use some accrued leave for recovering from those side effects. But there have been a lot of questions about testing, and this is a gray area, and I'll cover that now. The rule does not require employers to pay the costs of testing. That's stated under the rule. But under the Fair Labor Standards, which provides the rules about how you pay employees, paying them for all time worked and overtime, bonuses, employers are required to pay employees for time spent waiting for and receiving medical attention at their direction or on their premises during normal working hours. And the Fair Labor Standards Act also requires that employers pay employees for all hours worked, including their time on their vacation day, if the task they're required to perform is necessary for the work they're paid to do. So there's a somewhat of a disconnect between OSHA and the Fair Labor Standards Agency, which they're both under the Department of Labor. And it's my understanding that they will be working together to provide guidance to you as employers about exactly what you're required to do as for wage hour purposes. So for many employees, undergoing COVID testing may be compensable their time because the testing is necessary for them to perform their job safely and effectively. So while you don't have to pay the costs of testing, you may be required to pay them for the time they're spending doing this as a requirement for working for you as an employer. So you need to be mindful, and of course we can help you with questions you may have. And there are also state laws, which I'll cover later in the program, that also may require employers to cover the costs of expenses for things such as testing for employees. So employer notification to employees, what do you need to do to inform your employees about the requirements under this rule, and how should you do that? So you must inform each employee in a language and at a literacy level that the employee understands. So that really depends upon your employer, your employees, and the type of work they're performing, the operations, as to what that literacy level would be, about the requirements of the rule, including your policies, the procedures that you'll be using to determine vaccination status, your rules regarding time and pay and leave that they're required, that you're required to provide to them, and what type of leave that they will be required to use, procedures they'll need to follow to provide notice of a positive COVID test or diagnosis, and the procedures to be used for requesting records. And we'll talk a little bit more about that. You must provide additional information to unvaccinated employees, including information about the efficacy of the vaccine. Under this rule, OSHA strongly encourages the vaccination option, and there's a publication, Key Things to Know About COVID Vaccines, that's available, and in the slides you'll have access to the website where you can find that. But OSHA wants you to provide this information to your employees to encourage them to become vaccinated. Also, you need to advise them of non-retaliation provisions and penalties under OSHA for failure to comply. So how do you notify employees of these requirements? So the manner in which employers provide the required information to employees may vary based on the size and type of your workforce. You have flexibility to communicate this information to employees using any effective methods that you typically use to communicate with your employees. And again, in a language and at a literacy level they'll understand. For example, you can provide this information to employees through email, printed fact sheets, or during a discussion at a regularly scheduled team meeting if you have those. So the option, just what works for your workforce and the ways that you choose to communicate with your employees. So how does an employee communicate that they've tested positive for COVID, which a lot of people are doing right now? So regardless of vaccination status or the testing requirement, you must require each employee to promptly notify you when the employee receives a positive test or diagnosed with COVID by a licensed healthcare provider. And you must immediately remove them from the workplace until they are cleared to return to work or receive a positive test that they are no longer contagious and have the virus. So, right now we're seeing a lot of breakthrough cases of people who have been vaccinated, even boosted, and are still getting the Omicron strain. Record keeping requirements. So under the rule, you're required to retain either a physical or a digital copy of the documentation of an employee's vaccination record. And so for proof of vaccination to be acceptable as proof of vaccination, the documentation should include the employee's name, the type of vaccine administered, the dates the vaccines were given, the name of the healthcare professional or clinic, or where the vaccine was administered. And the rule provides that in some cases, state immunization records may not include one or more of these data fields, such as clinic site. In those circumstances, an employer can still rely upon the state immunization record as acceptable proof of vaccination. OSHA notes that clinic sites can include temporary vaccination facilities used during large vaccine distribution campaigns, such as schools, churches, or sports stadiums. So I know that a lot of parks were used, were set up as makeshift clinics for the vaccination. So as much as this information as can be provided based on the available data fields should be provided to you. So roster of vaccination status, you're required to keep a list or a roster of all employees and clearly indicate for each employee whether they are fully vaccinated, partially vaccinated, not fully vaccinated because of a medical or religious accommodation, or not fully vaccinated because they've not provided acceptable proof of their vaccination status. And although unvaccinated employees will not have proof of vaccination status, obviously the standard requires the employer to include all of this information on the roster. And it's really important to note that the roster and the records are considered medical records. So they're considered to be employee medical records, and similar to what you've done under the Americans with Disabilities Act, you're required to maintain these securely so that locked in a cabinet, protect the confidentiality of these records, and they may not be disclosed except as required or authorized by this rule or other federal law. And OSHA considers these vaccination records, again, to be medical records because they involve the health status of the employee and personally identifiable medical information. So very important that they be maintained confidentially, and you provide for that as part of your record keeping. There are very strict requirements for reporting by you to OSHA. You don't have to voluntarily submit information to OSHA or send them this, but if you are contacted by OSHA and requested to provide information, you must have this information readily available. So you must report to OSHA each work-related COVID-19 fatality. For this slide and this information, you are required to provide this information to OSHA within this set period of time. And then we'll talk about the other requirements with OSHA and record keeping. So here you're required to report to OSHA each work-related COVID-19 fatality within 8 hours of you learning about the fatality. So a key provision here is work-related. So did the employee get COVID at work? Is this a work-related fatality? So that involves a lot of contact tracing, and there are factors to determine whether or not it's work-related. And then each work-related COVID-19 inpatient hospitalization must be reported to OSHA within 24 hours of you learning about the inpatient hospitalization. Again, both of these reporting requirements by you to OSHA upon learning of this information focus on work-related fatality and hospitalization. So if many employers have questions about that, and there are some criteria that we can share with you and help you understand what your compliance obligations are. You must provide your written policy and aggregate numbers to the Assistant Secretary of Labor for examination and copy within 4 business hours of a request. So it's very important that you have the roster and records and proof of vaccination already, because when OSHA comes knocking, you only have 4 business hours to provide that information to OSHA. If an employee or an employee's authorized representative with consent makes a request to inspect and copy their own records or this employee's test records, you must provide those by the end of the next business day following the request. And I think this applies in situations where the test results may go directly to the employer and the employee wants to access his or her own records. So those must be provided by the end of the next business day following the request. Disciplinary action by employers, no retaliation or interference. So on this slide, I have 2 bullet points. One, the Act does not prevent employers from taking disciplinary action against employees for engaging in activities that are not protected by OSHA. And this includes violating the company's policy. So if employees fail to comply with the requirements set forth in the policies that are provided to them in a language and at a literacy level they understand, they are expected to comply with those requirements, and if you take disciplinary action, then that would not be considered retaliation or interference, of course, subject to the facts. And if there's any question, you certainly want to understand what your risks are and maybe get some guidance on that. But you may not discharge or in any manner interfere or retaliate against an employee for exercising rights that they have under this act. So, making sure that their rights are protected regarding what's required of them is so it's a line there that you're allowed to discipline, but the facts, there are oftentimes in these retaliation cases, in the absence of direct evidence, the case is made based on circumstantial evidence, maybe timing, maybe circumstances, maybe other actions that have been taken to indicate that this is not based on violation of a policy, but rather is in violation of exercising rights or whistleblowing against the employer. So a fine line there. It's also really important to understand the state laws and even local ordinances where your business is operating, because there are several states that have enacted laws that some prohibiting a vaccine mandate that conflict with this rule, and other states that have requirements about what you need to pay employees for example, for the costs of testing. So it's really, some of these are state by state. You really need to understand what the rights and responsibilities are under these state laws. So for example, I'm going to talk about a Florida statute. In Florida, there's a fairly recent statute that prohibits private employers of any size from terminating an employee due to a vaccine mandate without providing requested exemptions. And these include medical, actual or anticipated pregnancy, religious beliefs, COVID-19 immunity, periodic testing, and PPE. And unlike the requirements of Title VII or the ADA, under this statute, the employee just presents to the employer a form stating, basically, I'm exempt under this provision. So that's in direct conflict with federal law. And in the rule, in the OSHA rule, OSHA states that the federal rule and federal laws preempt state laws that conflict. If a state law provides more coverage or protection, that would not be deemed to conflict with the rule. But under OSHA's view, the federal preempts this state law. However, many employers in Florida have struggled with how they what their risks are by not complying with the Florida statute. So there are a lot of questions that are raised, and you really need to be mindful of this and get some guidance, understand what's required of you in those states if you operate in multiple states. Also in Texas, Governor Abbott had issued an executive order that no entity in Texas can compel receipt of a COVID vaccine by any individual, including an employee or a consumer who objects to such vaccination for any reason of personal conscience, based on a religious belief, or for medical reasons, including prior recovery from COVID. And finally, the last bullet point there provides that New York's former mayor de Blasio, who left office right after New Year's Eve, announced a first in the nation vaccine mandate for private sector workers that became effective on December 27th. And it applies in the city, New York City, but there are penalties starting at $1,000 for businesses. Of course, they encourage voluntary compliance. So there's a lot for you to grasp and think about and come into compliance with. Go to the next slide. I'm going to conclude by just making some general comments. It's really important that you decide what you want for your workplace. Do you want to have a mandatory vaccination policy? Do you want to offer the alternative testing and face covering? How will you handle the testing requirements? There are options for pool testing. How will you manage that? And I think that may be based on the size of your workforce and issues of cost, all of those practicalities of how you implement that. We can help you in our labor and employment practice group with the policies, guidance, information to be provided to your employees, and with questions you have regarding this. I think it's really important to understand that, this is just constantly emerging. Our Labor and Employment Practice Group has been providing you with some updates as they, news alerts as issues develop, and when the Supreme Court rules, we'll certainly follow up with you and provide that information to you. We'll continue to keep you updated. I just saw that there was a question regarding, will we be providing information or a webinar about the CMS rule for healthcare workers. And certainly if there's interest in doing so, we're available to provide that for you. So we encourage just good communication here. Let us know how we can partner with you and help you maneuver through this. We understand that it's a lot while you're running your businesses to try to make sure that you're in compliance. There are a lot of technical requirements, so we're here to help make this easier for you, help you digest this. We'll continue. If we can't answer all of your questions right now, we'll please follow up and we'll respond to your questions and make sure that you get the information that you need.
So Gail, to that
Yeah.
point, Molly believes there's 2 questions that you might want to address before we sign off. So with that,
Okay.
I'm going to turn it over to Molly to ask you the first question, and then she'll ask you the second question.
Okay.
Thanks, Gail. One question we received in the chat that I thought might be relevant to everyone is, are the requirements for January 10th and February 9th still in place regardless of the current stay?
They are in place. They are in place now. So employers should be moving forward. Now, what the Supreme Court will do, Justice Alito today asked about an administrative stay. Justice Sotomayor asked questions about, well, you know, really we have until February 9th for the testing. So would it be a problem to have some kind of brief delay? So there were questions asked about some delay, but the Sixth Circuit did lift the stay. Now the Supreme Court is being asked to put that stay back into effect. But as of right now, these deadlines are in place. The Department of Labor has indicated that it will, as an agency, exercise discretion in enforcement of this. And what they're really looking for right now is, are the employers undertaking good faith efforts to comply with this rule? So whether I think that there's a sense that the department will work with employers. There are penalties that are out there for non-compliance, but it appears from some of the guidance that OSHA will be focusing right now on good faith efforts for employers to comply.
Thank you. And the next question we had is about vaccination documentation and obtaining proof of vaccination documentation. How do boosters factor into this? Does fully vaccinated include boosters?
And that's a very good question. And fully vaccinated under the rule just means the full dose. So the 2 doses of the Moderna and Pfizer and the 1 dose of J&J, and boosters are not factored in there for the definition of fully vaccinated.
Molly, we still have a little bit of time. Are there other questions that would be helpful to go ahead and answer?
Yes. So what about religious beliefs? Who or what decides religious beliefs?
Yes, so that's a very good question. And there's guidance by the Equal Employment Opportunity Commission under Title VII as to that dialogue regarding sincerely held religious beliefs. There are some questions that employers can ask employees to, as part of that accommodation process. And there is guidance on the EEOC website. And in addition, we can help you specifically with some of those questions. But basically, it's a very liberal definition of sincerely held religious beliefs. In other words, employers, it's very difficult for employers to say that an employee does not have a sincerely held religious belief. But there are some questions that can be asked as part of that interactive process that may be helpful in fleshing out that issue and determining there is a sincerely held religious belief. So there is guidance on the EEOC website, and there are also some forms and questions that we can help you with as well.
What about those who work exclusively outdoors, but share a vehicle traveling to and from a job site? Or in the example you shared, a team of landscapers that ride together to and from each location?
Yeah, the rule, if they're in a vehicle with another employee, then the rule would apply to them, as I understand it, because the key is that they're not exposing other employees. So they would need to, those who work exclusively outdoors are, the rule does not apply to them, but if they're in a vehicle with another person, then I believe that the rule would apply because the exposure would be there.
And then we had a question about contact tracing. They understand the requirement to remove from the workplace anyone with a positive COVID result. But what about any employees identified as potentially exposed to the positive employee through contact tracing?
Yes, the rule for notification applies only the positive COVID test and diagnosis. And as far as I've seen, and I can go back and double check that, we can get the name of the person and I can follow up, but the notification requirements, as I've seen, apply to those who've tested positive. So in the case of an exposure, I haven't seen the specific requirement, or it's not jumping out at me, but certainly we can follow up on that.
Great. We have a question about disciplinary action. By not preventing it, is the act essentially requiring it because we have to enforce compliance with the policy?
Can you repeat that one more time? I'm sorry.
Yes, by quote, not preventing it, is the act essentially requiring it because we have to enforce compliance with the policy?
Yeah. So yes, the government, if this rule stays in effect, employers are required to enforce these policies. And then if employees refuse to comply, the employer basically has the right to undertake disciplinary action. Now, is the employer required to terminate the employee or take disciplinary action? If the employer would no longer be in compliance with the rule by allowing the non-compliant employee, the employer really would be required to take that disciplinary action to make sure that it's implementing and enforcing its policy.
So do you have any guidance on leeway with progressive discipline versus immediately terminating employees who do not comply by the deadline?
I understand under the rule that employers have some discretion there regarding what their disciplinary process is. And if an employer is a unionized employer, there may be certain requirements under a collective bargaining agreement, but I think the employer can follow its disciplinary policy. So it doesn't require termination immediately if there's a progressive disciplinary policy in place. And that should be all spelled out in the policy that is provided to employees and shared with employees.
So I think we have probably time for one more question. Can employees of companies with more than 100 employees hold their employer liable in case the employer does not implement any COVID policies such as mask vaccination requirements, etc.?
So in other words, is there a private right of action by the employee against the employer? As I understand, this is an OSHA rule, so OSHA would be enforcing this. The government would be enforcing this against the employer. And whether or not an employee has a cause of action against the employer based on not being protected, that could be subject to state law, various causes of action, workers' comp case. These are all, possibilities out there. But in terms of the rule and enforcing the rule, that's for OSHA to enforce against the employer.
And then we have a couple of questions specific to the healthcare workforce that might be better addressed offline. But what if the employee is only provided a verbal positive at their testing site?
Well, there should be a test result that's given. So there should be some documentation of the test result. And we can follow up on what information they need to get and what the employer's follow-up should be on that.
Great, thanks, Gail.
Well, I thank you all for your time, and I know there's a lot of work to be done, so please let us know how we can help you. And I appreciate you taking time out of your busy day to be with us here today.
Thanks, Gail. Everyone be looking for an email from us later this afternoon that will have a link to this recording. We'll have a copy of the PowerPoint presentation, and we will start answering some of the questions we were not able to get to as well, and get those answers to everyone who attended the session today. Hope everyone has a lovely afternoon, and we'll talk to you soon. Bye.
Thank you. Bye.